Welcome to Sakshi TV special immigration talk show with attorney Mr. Parvathaneni. Please note that Sakshi TV now has 4 immigration shows every week. On Tuesdays with Kaveti, on Wednesdays with Ms. Prashanti Reddy in English, on Thursdays with Parvathaneni, and on Fridays with Banu Nindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call us at 8667257441. Before we begin the show, please note that the information provided on the show is not legal advice and for general informational purposes only. Sakshi TV or its agents will not be responsible for the use of information, but if you need any consultation, you can definitely log on to their firm and ask them questions. SVVlawfirm.com site needs no introduction, but if you need consultation, you could definitely log on. And there is a wealth of free information and online tools in the hand of the immigration community where you do not have to be a lawyer to understand. Let me introduce you to Mr. Parvathaneni garu. Parvathaneni garu, welcome back to our show, Andy. It's always my pleasure to have you on our show. How are you?
Thank you, Shivani, and I'm pretty good. And thank you all Sakshi TV viewers for joining in today.
Yes. So Parvathaneni garu, today, we will get on ahead with our topic today. But then before that, let's get into some latest immigration updates. Do we have anything that we have to discuss?
Sure. So we are in the month of September, and September month is pretty crucial for immigration because the fiscal year for immigration ends on September 30th. What that means is any of the new H1Bs, any of the new green cards, the count resets from October 1st. So September is the time where they close out all the immigration numbers. October 1st is the start date of the new fiscal year. And what that typically means is for somebody that's coming on to H1B for the very first time, we have seen a lot of approvals come through already, and a lot of cases are getting processed very quickly. So the new H1Bs, their start date is October 1st. One has to be very cautious. A lot of employees are changing from F1 status to H1. And when they change to H1, they have to be aware of a couple of things. They have to make sure they are working with the right employer in the right work site where they're supposed to work as per their LCA. They have to make sure they're getting paid as per their LCA. And overall, make sure they're compliant with all the H1B regulations. Because when they're on OPT, rules are a little bit different. And October 1st, for a lot of those people who got approvals, things will change. So one thing to be cautious about, October 1st. Another thing with the green cards. With the green cards, the new visa bulletin for October has not come out yet, and it will come out in the next couple of days. And what that means is typically we see movement in October bulletin because October is when the new numbers will get rolled in, the new visa numbers. So October, November, December bulletins, typically we can expect to see some movement, something to watch out in the next couple of days. And on another side, October 1st, so in India, there are some rules that are being changed, which could impact anybody that is interested in filing for an investment EB-5 based visa in US. The reason is previously it used to be 5% tax. Now the tax is getting changed to 20%. So there are rules that are coming into effect in India from October 1st. So anybody that is interested in pursuing EB-5 investment-based visa and who are in the process of moving funds from India to US, be aware that there are new taxation rules that are coming into play in India from October 1st. And this will impact if they have to move funds from India to US, because the 5% is now going up to 20%. Initially, it was supposed to be implemented a few months earlier, but it got pushed to October 1st. And it's one thing that anybody that is looking for EB-5 investment-based options to be aware of.
Yes. So today we thought we'll discuss about the deportation that has been happening continuously for the F1 and the H1B visa, Mr. Parvathaneni garu. So so what are some of the reasons that the CBP, which is the Customs and Border Protection Officer, may reject for the entry of the F1 students. But before that, can you just give a brief to the viewers about the recent deportation of the students that have come to USA, and they were deported back as soon as they landed in the country. First, give a heads up about what exactly happened there, Mr. Parvathaneni, and then you can answer this question.
Sure. So in general, anybody that wants to come to United States, the first step is to go to the consulate and get a visa. And that's what all the students who have been involved in this situation, who have been deported back, a couple of them. So all of them, just like any other student, they get a visa. So visa is the very first step to come to United States. However, the general consensus, the general view is that the minute you get F1 visa or any kind of a visa, it is a guarantee to be admitted to United States. However, the reality is visa is not a guarantee of being admitted to United States. Visa is just a permission slip to board the flight to actually arrive at the airport or at the port of entry. So the visa only is a permit to enter the port of entry. So up to port of entry is the permission they get using a visa. At the port of entry, so they have an interview with CBP officer, the Customs and Border Protection officer. That officer is the one that will decide if somebody can be admitted into the country or not. So basically what this means is the officer has to be convinced that whoever is coming into United States is going to follow the terms of their visa. If it is H1, they have to follow the terms of H1. If it is F1, terms of F1. If it is somebody on visitor visa, follow the terms of their visitor visa. So everybody has to go through an interview with the CBP officer. And unfortunately, what has happened recently is there were a few students who were impacted and they were sent back. And unfortunately, at least from the news that is coming out, multiple people were deported on the same day. So again, these kind of expedited removals happen all the time. I mean, we keep hearing about this all the time. However, it is not in great numbers. It is very, very minor numbers because few people who really have an issue are the ones that typically get deported back, put back in expedited removal and sent back. And unfortunately, last month, August is typically also the month where a lot of F1 students come to US for the first time, because August is when most of the universities start admission, the universities here in US. So a lot of students do come in August. And unfortunately, a few of these folks were deported back. And I think that's what we have heard about it. And I think in general, there is a recommended process on what everybody should follow. And I think the goal of our show today is to make sure everybody is aware of the laws and they follow the proper procedure to minimize the chances of getting sent back to India from port of entry.
Yes. So if someone is on H1B H1B visa instead of the F1 visa, what kind of reasons might the custom officer use in order to reject the entry at the airport and send the employee back? And also, can they actually do it for people who are on H1Bs too, or is it just limited for the F1 visa, people?
Yeah. So technically, even H1 is a non-immigrant visa. So even if anybody is on a non-immigrant visa, the rules are pretty much the same as far as the CBP officers are concerned. And their role is they are entrusted with the safety and the security of United States. So whoever is coming into the country, their task is to ensure they're coming in for the right reasons, for the reasons which they're allowed. And what that means is, as a part of their admission process, the CBP officer, they have to interview the non-immigrant visa holder. So for the H1B employees, the rule is they are supposed to come to United States. They have an employer. They have an employer who has work where they're supposed to work from a particular location, and they're supposed to get paid a certain amount of money. And the CBP officer, what he's checking mainly is the employee coming in to work at that company? Is the company legitimate? Is the employee legitimate? Like he said, he is. And wants to make sure he is coming in just to work at that company. So that is their goal. And as a part of their questioning, they also want to make sure that the employee is a legitimate employee, and if they have been in United States in the past, if they were in US in the past, either in student status or maybe working for another employer. They also ask questions sometimes to make sure they have always followed the law, they have not violated their visa conditions. And for the H1B employees, so what happens is, if they find out there has been any issue in the past, either they have misrepresented anything in the past, or they're lying during the inspection process, during this interview process, they're going to use it against them, and they could be sent back. And that is what we see occasionally, time to time. And what we also are noticing is, there are sometimes some port of entries. There are more cases where we hear about this kind of issues a lot more. That being said, normally what we have seen is, the reasons that they have, they're always most of the time they're justified, because the CBP officers, they're trying to do their job. So unless they really have a reason, they typically will not deport people back. And what that means is, the number of people who are sent back, the number is very minute. It is very small. So in spite of a lot of bad publicity that we have seen in the last couple of days, because a couple of the students were sent back in one single day, overall, in general, the number is not very high. The number is small, because the CPP officers, they do have to justify the reasons, and they have to give it in writing, the reasons for sending somebody back. It is always in writing, and things are documented. And what that means is, unless there is really a reason, a justifiable reason, typically people are not sent back. So what that means is, for the H1B people that we have seen sent back, I had one recent issue, and it was just in the last 3-4 days. And the reason he was sent back is because his phone was taken. And what they have seen is, they have seen something on the phone, and it was not matching what the employee was saying. The employee was saying something about working for a certain period of time, and on the phone they found out that he was not really working for that period of time. They documented those reasons, and they proved to the employee that the employee lied to them. So, and they documented everything, what kind of questions they asked the employee, what kind of answers the employee gave them, and then what they found on the phone. And when they confronted the employee with those uh, evidences, the employee agreed that he lied. So basically, so when somebody is able to prove that a mistake has been made, they have the ammunition to send somebody back. And what that means is, most of the time, and I would say almost all of the time, the CPP officers really have a good reason if somebody is being sent back. That being said, a lot of times some of the questions that I get is, why do we keep hearing things in a particular one or two port of entries? This issue keeps on recurring. What is the issue? And that is true, because in my opinion, I see a lot of cases like this happening in Chicago. And I don't think it is because the CPP officers are doing anything wrong. It is because I think they have more resources, and they're kind of checking phones, they're checking the devices. So end of the day, people are doing their job. So they are not using some illegal reasons. They do have legal reasons. But again, we do see some of the port of entries being more stricter. But again, the rule for everybody is, as long as they are following the laws, they typically won't have a problem. And the number of deportations that happen on the H1B side, it is not on a large scale. It is very minute. And most of the time, at least the cases that I see, the CBP always has a reason to justify the reason for putting somebody in an expedited removal, or rejecting their admission process.
Yes. And also, Mr. Parvathaneni Garu, what kind of documentation must the F1 student be carrying when they are actually traveling to the USA for the first time?
Sure. So a part of the CBP officer's initial inspection, the first inspection is looking at the main documents. And the main documents are always passport. So everybody carries passport in their hands. So there is no issue with that. But there are also other documents. And in general, one should always keep their I-20, the original I-20, with in their hand. I-20 is a very important document. And for all the F1 students, most of the time, the inspection officer will ask for the I-20. So I-20 is a very important document. But also, apart from the I-20, they should always keep their degree certificates, their bachelor's degree, or their mark sheets from their college in India. They should keep that handy. They should also keep their college admission letter, and most importantly, they should keep proof of their finances. When I say proof of finances, a lot of these F1 cases where I have seen an issue happen in the last couple of weeks is regarding the financial evidences. The main thing the officer wants to know is how are you going to pay for your education. They want to make sure somebody is not working in an illegal job. They're not working in a gas station. They're not working in a hotel. They're not working in a restaurant to pay their fees. They are very, very particular about that. There are strict laws on on what a student can do and where a student cannot work. So there is a very good chance that the officer is asking about the financial documentation. How are you paying the fees? Do you have the money in your bank account, or what is the source of your fees? And what that means is, if somebody is not able to answer questions about their finances, how they're going to fund their education, they might have a problem. Okay, because the USS office, the CBP officer, might think that they're not going to, they're not intending to study. If they're not able to show evidences of their proof of funds to pay for the college fees. So that is very important. So out of all the things, I think the proof of funds is very important. And depending on the universities, every university will have a different way of getting their fees paid. So make sure they know how, make sure you educate yourself with how to pay the fees for the university where you're going to do the F1 program. Make sure you present evidences clearly to the CPP officer, so the CPP officer knows that you have funds readily available to pay your fees, and this is how you're paying the fees, and everything adds up. And that is what they're trying to check. And most of the issues that I've heard, they have found issues with their sources of funding.
Yes. Let's talk about secondary inspection. Let's say that they were not allowed an entry in the first inspection. What kind of other documents will the CBP officer ask for the secondary kind of an inspection?
So the primary inspection is basically you get out of the airplane and you stand in a line and you go to the officer that's when you're ready. So that is the first check. The same way that it happens in India. You go. So you go out of the airplane and stand in front of the customs officer. So that part is very straightforward. Most of the time, it's less than 5 minutes. So they don't take more than 5 minutes. In less than 5 minutes, for most of the people, they stamp the passport and they admit them. And for those unfortunate folks who have to go through the secondary inspection, the officer will let them know that they have to go for a secondary inspection, and then they get sent to a second officer. So secondary inspection, it can take anywhere from a few minutes to even a couple of hours. I've seen a lot of secondary inspections where it continued for a couple of hours, a long time. So, and again, secondary inspection by itself does not mean that you're going to get deported. It means that they're not satisfied with some of the answers. They want to do further digging in the secondary inspection. And in secondary inspection, what normally happens that is different from the first inspection is, not only will they get asked some further intrusive questions, but the officers also have a right to take their devices. So they can take their phone, they can take their laptop, they can open up their laptop, look at their emails, take their cell phone, and look at their cell phone chats, look at WhatsApp messages. I've seen a lot of issues where the officer pointed out the WhatsApp chats. They said in the WhatsApp you said so and so to so and so, and that does not equate to what you're telling me in the interview. So they have shown WhatsApp chats and proved to the employee that they were lying. So in the secondary inspection, the officers have every right to inspect the luggage, their belongings, their cell phone, the contents of their cell phone, the contents of their chats, and everything. And that's what typically happens. And that's the reason why it takes a long time, because the officers have to do all these things. And in between, if they have issues, sometimes they consult their superiors, their supervisors, and so on. And at the end of this secondary inspection, typically 3 things happen. 1, they say, okay, everything is good, we'll admit you. 2, they will find some issues with some documents, but they don't think the student has done anything wrong. So what will happen is they will say, okay, we will give you deferred admission, And what that means is you can go into US, but tomorrow, once you get this document corrected, come back to our office to get a formal admission. So that happens rarely, but it does happen. And the third one is something that nobody wants, which is being sent back to the home country. And that is unfortunate. But if they find something bad in secondary inspection, uh, they will be sent back, and that will be the final outcome of secondary inspection.
Yeah. And also, Mr. Parvathaneni Garu, does like checking their phones and their private chats come under invasion of privacy? And like, do the CBP officer have the actual right to be doing what they're doing, by checking their phones, checking their chats? Can you explain a little about this?
Sure. So say if the same H1B holder or the F1 holder is inside US. So when I say inside US, they have been admitted to United States and they are outside the airport. During those circumstances, generally, they always need, the enforcement agencies always typically need a warrant. So they have to come with a warrant. They have to serve the warrant before they can inspect those kind of devices. But there is an exception to that. When they are in the airport, they're not yet admitted into the country. And when they're not yet admitted into the country, at that point of time, the CBP officers, they have an exception. So they don't need a warrant, but they can inspect the devices without a warrant. And that is what happens. So because they have this exception for searching their devices, what that means is even without a warrant, it is completely legal for the CBP officer to check the cell phones, to check the chats, to check the email messages. They can look at personal messages, and it is completely legal. And what that means is everybody that's coming into United States, they have to be aware that their phones can be taken by the CBP officer and be scrutinized.
Yes. So, Mr. Parvathaneni, do the students have the right to speak to the attorney or ask for an attorney during the inspection?
So that's another common question that a lot of people have been asking lately, because in the United States, so there is something called due process, and the country, the US, is all about due process. It's all about the fundamental rights, and what that means is everybody should have due process, go through the process, and if they have a problem, they have a right to consult an attorney. That is true, but again, there is an exception, and the exception is for somebody that's in the airport. The legal way to look at things is they are in the airport, but they have not yet been admitted into United States. If they are inside United States, they are outside the airport and inside the United States, they will have a right to attorney. But before the admission happens, while they're still interviewing with the CBP officer, since they have not yet been admitted into the country, they do not have a right to an attorney. They do not have a right to the counsel. And what that means is they can always ask, but CBP officers, for most part, will always refuse them, will always not let them speak to an attorney. And that's because legally they do not have a right to an attorney because they're on a non-immigrant visa.
Yes. And also, to which authority can we appeal the decision of the CBP's officer?
So again, last month we have heard of a few cases where a lot of the students were sent back to India, and a lot of people are asking, what can we do about it? And it's not only the F1 students. I've also seen a couple of H1B folks sent to India last month. And again, the number is very, very small, but these kind of cases keep happening. So what is the legal recourse that one can take when they are in that bad situation? So when the CBP officers put somebody in expedited removal or send somebody out of United States, the options are very, very limited. And the reason for that is they cannot go to an immigration judge. They cannot go to the federal court to argue their case. The only option is they can go to the same CBP office and they can file a motion within 30 days and they can request for a review of their case. So a supervisor can review their case. And what that means is they have to act very quickly. They have to basically document all the legal points and show where CBP got it wrong. And they have to request for a review. And they have to do it at the same CBP office. So what that means is theoretically, you're going to the same office where you got this issue initially. but you can't really go to the court or you can't really go to an immigration judge for further review.
Yes. Mr. Parvathaneni, my next question to you is, what happens if the candidate refuses to voluntarily withdraw admission to USA? In what circumstances can they order expedited removal?
So when somebody is trying to enter United States and the CBP officer does not want to let them into the country, so typically the CBP officer has two options. One, he can put them in expedited removal, and what that means is he does not have to go in front of a judge. He can be the judge and he can decide that somebody needs to be sent back to their home country. Or he has a second option. The second option is he can ask the applicant, the visa holder. He can give him a choice. He can say, do you want to withdraw your admission request? And do you want to go to India at your own expense? There is a difference between the two things. One, if the officer sends him back by putting him in expedited removal, the person, the H1B or the F1 person, they will have a 5-year bar. This is very, very important. So if the officer is trying to deport you, always one should ask the officer, can I withdraw the admission? Can I go to my home country with my own expense? Because if the officer lets them withdraw the admission process, the 5-year bar is not there. So it's a very, very important thing. So if the officer says, no, I will deport you back by putting you in expedited removal, the person will have a 5-year bar. So they cannot come to United States for 5 years. So there are two choices. One, the officer can send somebody back in expedited removal, or the officer can give somebody, he can accept the request for withdrawal of admission. So they can withdraw the request. So our recommendation is, you should always, if you're in a bad spot and you know you're going to be sent back, always ask the officer if you can withdraw your admission request. Okay, and what that means is at least you not have a 5-year bar. And if you force the officer to send you back by expedited removal, you will have a bar. So the two options both are bad, because both of them will put you back on a flight to India. But with at least one option, you can save that 5-year bar. You won't have to be barred for 5 years, but you can go back to India. You can go back to the consulate and again let them know what has happened. Again, reapply for a visa. And if the visa officer gives you the visa, you don't have a bar. So you can always come back and have a fresh start.
Yeah. I think we can continue with other set of questions in the next episode, Mr. Parvathaneni Garu. Thank you again for tuning in. Thank you for the viewers for watching Sakshi TV. You're watching me, Shivani Raj, and this is signing off.